Hello, hello, everyone. Nicole Gaither, trademark and copyright attorney with Sage House Legal. And today we are going to talk about one of my favorite subjects, copyright and tattoos. So this is based on some recent cases that have been in the news involving tattoo artists suing. This is not the same thing that's happening on with the Cardi B mixtape. That's a completely separate issue, and we can address that another day. But today we are looking at tattoo artists who are suing for copyright infringement. And the question I'm posing based on this recent case that was decided last month is, could your tattoo artist block your income opportunities? And this recent case makes it a strong possibility. But before we go any further, so that we're all on the same page, yes, tattoos can be protected by copyright. I know, right? That's because they're creative pictorial works that are fixed in or on, in the subject of the fact that it's a tattoo on your body, on a physical object, being your body. The tattoo artist also owns the copyright in the tattoo unless they turned it over to you. So if you're selecting some artwork from their portfolio, they more than likely, hopefully, drew it themselves. So they own the copyright in that drawing. And now they're going to own the copyright and putting that drawing on you. Unless you sign over unless you bring your own artwork to them, or if you sign, you have an assignment agreement in place. So, just something to consider. Most will a tattoo artist do that for you? Not sure. I've never actually asked one of them, but just be aware. So anyway, back to this case, and I'm actually going to, because we need to see what is actually happening here. I'm going to share my screen and show you all what I'm talking about. So let's see. All right. So WWE, Worldwide Wrestling Entertainment. When I was growing up, it was WWE and WCW. Apparently they've merged and they all became WWE. However, back to this matter. So Randy Orton is a wrestler for WWE. He, had this tattoo artist, Catherine Alexander, ink him between 2002 2008. And he was also featured in Take-Two Interactive's WWE 2K16, 17, and 18 video games. And they clearly depicted his tattoos because they were depicting him. So they put the tattoos for everyone to know, like, this is Randy Orton. And we know Randy Orton because he's got, these tattoos which appear to be on his arms, or so like sleeve tattoos. So the tattoo artist approached Take-Two to negotiate a licensing deal for the use of her, tattoos on, in this depiction of Orton. They rejected her proposal and then offered her $450 to use the tattoos. Well, you can probably guess why we're here, because Alexander refused that $450 and sued them. And I'm going to stop sharing because this is where it gets interesting. All right. So last month, a jury awarded Alexander $3,750 in damages, and that is $3,750 in damages. And that is because the court determined that, yes, she was entitled to damages for the use of the tattoo of her work. So it was, determined to be copyright infringement. However, they didn't give her major damages because they felt that she wasn't entitled to any of the profits because it wasn't her tattoo work that, helped them make money. Strange, but true. Anyway, the problem with that is this creates an interesting precedent regarding the use of tattoos in video games. So, this goes back to, there was a case, involving LeBron James's tattoos. There have been several, like where, depictions of athletes in video games features, their tattoos and things that are distinctive to them, where the tattoo artist has, later come and sued. We've also seen this kind of in movies with the whole Mike Tyson tattoo that was featured in Hangover 2. But this case is bringing some, new things into the mix. This could open the door to tattoo artists suing for the use of their work that they see in photos and movies and in artwork. So you as a person, an individual, could also possibly be subject to this, if this case, sets that precedent. What if you're an influencer and you have tattoos on visible body parts and you're, showing, how you're using like a skincare product? Well, can the tattoo artist come after you for using your hands that might have a tattoo on them in a video because it's now considered a public display, which is one of the rights that a copyright owner has to publicly display their work, not, for someone else to? Or what about an actor in a movie or a model? What happens if the artist refuses to grant permission for the use of the tattoos, for allowing them to be visible? Does the actor or model have to wear makeup? Is that an option based on what is needed, like, or what, their tattoo is, or like what it covers? Like, is there, makeup going to do that? And what if the filmmaker or company, tries to reason and work with the artist and the artist, still refuses, does not want to even take payment because they just don't want their tattoo featured? And, they do have that right as copyright owner. But what if the filmmaker or company decides that they don't want to deal with the potentials? Like maybe some of them are like, oh, we'll just take our chances. And others are like, we don't want to deal with this because this could give us, this could be bad publicity for us. We might have to, deal with litigation, which can get costly, even if we prevail, all those things. So these are things to consider as a result of this case. So definitely there is more to come. But again, Nicole Gaither, Sage House Legal, trademark and copyright attorney with all things trademark and copyright. And I will be back with more interesting tidbits about cases in pop culture. All right. Have a good one, everyone.